It's the Law.
Welcome to It's the Law, a program produced and presented by the Guyana Association of Women Lawyers. On this program, a member of the association gives us an in-depth look at Guyana's laws. On today's program, we hear from Keisha Chase, who has been in the profession for 12 years.
Today we're going to be discussing maintenance and alimony for a spouse. So maintenance is the obligation to provide another person with housing, food, clothing, education, medical care, or with money to obtain those things. The law in Guyana imposes upon a person a duty to maintain their children, parents, grandparents, and specifically for today, we're dealing with husband or wife. Yes, I said husband. A wife can be made to maintain her husband once it is proven the requirements that I will discuss a little later. The laws in Guyana relating to maintenance are set out in our Maintenance Act, Chapter 4503, for spouses. As I indicated, there is maintenance for children, but that is contained in the Custody, Contact, Guardianship and Maintenance Act number 5 of 2011. Both maintenance acts provides for one person maintaining their husband or wife if they are in a government hospital, home for destitute persons or otherwise. How do we apply for maintenance? Guyana's High Court of the Supreme Court of Judicature, there is the family court. In the family court, it is governed by the family rules of 2016, and an application can be made by way of a notice of application for maintenance. This can be made along with any other application that deals with the family. So for example, if you have filed for divorce from your spouse, you can also file an application requesting the court an order for the opposing spouse to maintain you at the lifestyle that you were accustomed to while you were married. Applications for maintenance, you must prove one, that a person can maintain you, which means that they have the financial capacity, the earning capacity, that there is an income, that they may have property or other financial resources that they can utilize to maintain you. This must be proven by the applicant, that is, whomsoever files the application for maintenance, that is the person who must prove that the opposing spouse can maintain you. These applications are not limited to the High Court. If it is simply an application for maintenance and you may be common law spouses, or you were previously in a relationship that may not have satisfied 5 years, but you have treated each other as husband and wife, you can file for maintenance in the magistrate's court. An application for maintenance is not limited only to married parties. It can be on behalf of former spouses. There are two limbs for maintenance. There is maintenance while married and thereafter permanent maintenance. While you're married, that maintenance would continue until a decree absolute, which would be a final determination of your marriage. That continues up until that date. Thereafter, you can approach the court for permanent maintenance, which means we were either together as common law spouse and we have parted ways, or we were married and it's now legally determined that that marriage has come to an end. The requirements for maintenance. I stated that there must be proof of financial capacity. Financial capacity includes a person's income from a fixed job, or if they are self-employed, that you have an idea as to what they earn during that time. For example, when I say self-employed, it could be a bus driver, a taxi driver, even attorneys at law. For spouses, if you are working and you are filing an application against your opposing spouse or former spouse, your earning capacity is also taken into account by the court. If a person cannot maintain you when the court looks at all the financial obligations of that person, then they would not satisfy the court as to the extent of their capability to financially maintain the other person. Maintenance of spouses. Let's start specifically in the magistrate's court. An application can be made through an attorney at law, or an application can be made in person. You would visit the magistrate's court closest to your residence. You visit the registry, and you're assisted by the staff of that family court, that magistrate's court registry. They would take certain information from you. One document that, if you are in possession, if you are married, must be your certificate of marriage. Once that application is filed, it must be served on the opposing spouse by way of a bailiff or a police officer in the district. They are trained to assist persons who appear with summonses prepared by the magistrate's court for maintenance. When it is served, a court date would be stated on that document. That document now, the person who receives it either retains an attorney or appears. If they appear either with an attorney or by themselves, the court asks certain questions. If they can provide a salary slip or payment slip, if they are working self-employed, for them to prepare an affidavit of income, swearing that they are employed as whatever profession they operate, and how much they would earn either weekly or monthly, and also ask them to set out what their expenses are. This is taken as evidence. Anything sworn in an affidavit is considered evidence to be considered by the court. If the parties cannot consent to a figure, the court does engage with them. They would involve probation officers to assist the court and the parties, whether they are represented by attorneys or solely in person. When that order is made between them, that agreement, the court can make that a final order. A final order for maintenance for a specific sum, by the court it is ordered to be paid weekly. This sum is paid to the collecting officer of the magistrate's court in whichever district you have applied. You would then be given a number, and you present that every Friday if you wish to uplift your money every week. The other opposing person who is paying, they also have that number to make payments on record. When that payment is made, it is for whomsoever made the application. It is their duty now to go and uplift. I must warn that once an order is made by the court for payment to the collecting officer, any sums paid outside of that, you stand and fall by whether the other person is honest enough to say they did receive the money. So I advise any person who has ever received an order for payment of maintenance for a spouse or child by a magistrate's court to make those payments to collecting officers only. There the record is kept, and there can never be any discrepancy or anyone saying they never received the money or the money was never paid. The court keeps the record. Maintenance orders can be varied or discharged. When I say varied, of course I mean to change. If I agree to pay $5,000 every week and I get a new job, I'm earning more money, I'm able to maintain the other person at a higher standard, and they approach the court for a variation of that order, asking for an increase. Again, they have to prove that the person they have taken to court is capable and their earning capacity can match the sum that they are now requesting. Variations are also available to the other side, that is the party who has to pay. He can come or she can come and say, I have lost my job, I have had another child, I am now remarried, I now have to pay rent, and I'm asking that the sum be decreased. They have to provide that evidence of a change of circumstance. The court considers the change of circumstance, and if the parties cannot agree by consent, the court takes evidence. Every matter can go to trial, but when it involves family members, the courts try to assist the parties to amicably resolve matters, explaining the law, explaining what each party has to prove to the court, and also considering there are other matters on the docket for the magistrate. Trials are usually a last resort. Now, if there is a failure to pay maintenance, it must be in excess. There must have been 4 weeks that have lapsed that a party has not made any payment. If that party has not made any payment, then the other side can approach the court and say, listen, I have not received any money. There is no record at the court that any sum has been paid in excess of 4 weeks. I wish to have an application for a liability to be taken out. A liability order really and truly calls upon the other person, saying you were liable to pay $5,000 per week for the maintenance of your former spouse or for your spouse, and you have failed to do so. They have now approached us to either seize items belonging to you and have them sold, or for you to be imprisoned for a breach of the order that the court has made. At this stage for liability orders, the court is not usually minded to sentence a person. So there are opportunities that may be given to the person who's being brought before the court and ask them to make payments, lump sum, explain the circumstances. That is why it's important that if there has been a change of circumstance and you're unable to make that payment you previously consented to or that was made against you, you come to the court. You explain to the court the circumstance and ask for a variation of the order. Liability is, as I said, is if a person fails to make those payments. The court has the options of making orders for deduction from your earnings. If you are employed at a fixed place, the court can make an order that your employer takes money from your salary and deposits it at the court. There is also the Matrimonial Causes Act, Chapter 4502, that deals with maintenance and alimony. Within that act, it says that if a court thinks it's fit on the decree of a dissolution of the marriage, they may order that the husband shall, to the satisfaction of the court, secure to his wife a certain sum of money, having regard to her fortune, and these are the requirements being listed here: her salary or her earning capacity, the ability of the husband, which is not limited solely to his fixed job, but he may have side businesses or companies in which he may incur an income, the conduct of the parties, and this conduct is, even though it is listed in the act as a consideration, it has to be deemed reasonable and for the purposes of the application for maintenance or alimony. Alimony and maintenance is not fixed, meaning not simply on the dissolution or the termination of your union you are entitled to maintenance. You must prove the requirements that I have listed previously, that the person that you're taking to court has that earning capacity. If I can just simply go over maintenance at this stage as I conclude on this topic. Maintenance is open to either husband or wife, former husband, former wife, common law union spouses, that is, parties who live together as single man and single woman in excess of 5 years. You must prove the earning capacity or income of the party that you're taking to court. The court examines that, including your earning capacity. So if it is that you were a housewife and your union has ended, the court looks as if you can secure a job to assist yourself with maintenance now that that union and that the financial burden that was on the husband, now that has been either limited or removed altogether. The court looks as if you can earn as well. The court also looks at if you are accepting maintenance and there are children as well in the union that were of the union, maintenance for them as well would be included. So as I indicated, maintenance applications being made at the High Court. I just wish to reiterate, which some of my colleagues have dealt with in the previous weeks. You can go to the Legal Aid Clinic at the Mirage Building and visit those attorneys. Or you can visit the Family Court Registry at the High Court and indicate to them what application you wish to make, and they offer assistance in the filing in person. So those options are available if a person may not be able to afford the services of an attorney at law.
You have been listening to It's the Law, a program produced and presented by the Guyana Association of Women's Lawyers. Today's contributor has been Keisha Chase. The contents of this program are not to be taken instead of legal advice.